Hello and welcome to Lunchtime Politics on Channels Television. I'm Millicent Walker. On the news this hour, the second-year anniversary, President Muhammadu Buhari's promises to ensure the freedom for Leah Sharibu, the schoolgirl left in captivity after the girls kidnapped in Dapchi community in the northeast. President's Day still keeps mum over what has become a subject of national discourse in the wake of the leaked memo from the NSA, Babagana Mongunu, over alleged meddling in national security matters by the President's Chief of Staff. And it has become a breathless wait over the position of the Supreme Court on the governorship judgment. It's been challenged by the PDP and Mr. Emeka Ihedioha. Welcome everyone to the program. Let's begin this afternoon with what is a sad memorial of the kidnap of 110 school children. It's exactly 2 years today since the children, most of them schoolgirls, kidnapped by ISWAP terrorists from the town of Dapchi in Yobe State. And on the second anniversary of their abduction, February the 19th, 2018, President Muhammadu Buhari restated his commitment to securing the release of all children held captive by terrorists. The president, in a statement, acknowledged that while 107 of the children survived the ordeal and were returned to their families, one of them, Leah Sharibu, now aged 16, remains in the hands of the terrorists because she refuses to renounce her Christian faith. President Buhari insists that no person has the right to force another to change their faith against their will and that all life is sacred. To quote the president, as we redouble our efforts for Leah's return, we can never allow the terrorists to divide us, Christian against Muslim, Muslim against Christian. We are all sons of Abraham and all Nigerians have the same worth and rights before the law and before God. Well, let's go over to some legal matters where the Supreme Court has adjourned till March the 2nd hearing of the application filed by the All Progressives Congress seeking a review of its judgment on the Zamfara governorship election. The court also adjourned to the same date hearing of the application filed by the sacked Imo State Governor Emeka Ihedioha for a review of the judgment that removed him. The adjournment of the Zamfara election hearing follows the inability of the APC to serve the processes on 8 of the respondents who are not in court, and neither were they represented. There has been an intense apprehension in Imo, for example, over the adjournment, as the players await the final position of the Apex Court. So now we find out what the thoughts are on the minds of politicians on this particular issue. We have joining us from Abuja studio, Mr. Hamad Gulag, a member of the All Progressives Congress, and we also have a former political advisor to the former president and a lawyer, Mr. Emeka Opara. We'd like to thank you both for joining us at this time. I must begin by asking, and this is, of course, to you, this is with regards to Mr. Emeka Ihedioha. Many people are wondering if indeed he is ready for the review. Why is his lawyer asking for more time? Because people are wondering, more time to regularize their processes. How ready is Mr. Ihedioha and the People's Democratic Party? This question I'll direct to you, Mr. Opara.
Yes, please. Thank you very much. I want to first of all say that my designation is Senior Special Assistant Legal Matters, not political. To answer your question, there is every readiness from the governor to pursue his matters. The reason for asking for an adjournment yesterday was because for more than 2 weeks, or rather close to 2 weeks, the respondents to the application were served, and they never responded, and they never served the side of Right Honorable Emeka Ihedioha until a day to the day before yesterday, day to the hearing. And normally, whatever issues raised therein have to be replied to. That is a right of the applicants. And we cannot just waive that right, because if they raise any issue in their own response and you don't respond, it means you have considered to those issues. That's the thing. So it is them that orchestrated the adjournment of yesterday. It is not the other way around.
Let's find that from Mr. Gulak. Do you agree with what Mr. Opara is saying? Do you think that there is merit in Mr. Ihedioha's application?
Completely, there was no merit. And I'm not surprised with what happened yesterday. They were not ready, and they can never be ready. These are people, after the Supreme Court has given its final judgment, have come back to approach Supreme Court again to review its own judgment. And after filing that process, followed it up with a letter asking all the 7 Supreme Court justices to recuse themselves from hearing and determining the matter. I don't know, for God's sake, why are we turning Supreme Court into a marketplace? You are the person asking the Supreme Court to review its judgment. You are the very person asking the 7 justices of the Supreme Court to recuse itself. Who do you want to hear and determine the matter? Is it Uche Secondus and its members of the NWC? In fact, in the name of politics, we should stop demolishing and destroying our institutions that safeguard democracy. In summary, Emeka Ihedioha, the former governor of Imo State, and the PDP know very well that the Supreme Court judgment was final. And in rare cases, the Supreme Court can only review its judgment under 3 fundamental situations. 1, to correct typographical errors. 2, to correct a slip that will change the meaning of the judgment. 3, if the judgment was obtained by fraud. None of these conditions exist for this review. And in fact, they know it. Lawyers know this, that the Supreme Court judgment is final. After Supreme Court judgment, you go home. Not because the Supreme Court is infallible, because they are final, but because they are final, they are infallible because they are final. They may make mistakes, agreed, we know, but in subsequent cases where lawyers know that if they discover that they made a mistake in their judgment, if similar cases come up in the future, they have every right to depart from their earlier judgment in an earlier case. But in this case, this is an election matter, which is the time frame has elapsed.
Mr. Gulak, let's hear from Mr. Opara at this point.
Section 258 of Section 7, after 60 days, the Supreme Court ceases to function in that case.
Mr. Opara, being a former senior special assistant on legal matters, you're well aware with some of the rules of court and some of the things that Mr. Gulak has said. But what's your response to that, especially to people who argue that this review is best an academic exercise?
I want to say that pandering to the Supreme Court or pandering to the court, what Gani Fahmy will call Kabiyeism, does not define the law. The law is very clear, and we are not arguing it from the street. The law is clear that when the 5 grounds that was brought before the court, under any one of those grounds, the Supreme Court can set aside. We are not talking of correcting typographical errors here. We are talking specifically about there was a matter, there was an appeal, and in that cross appeal before the Court of Appeal, and in that cross of appeal, the Court of Appeal struck out the petition of the respondents, and the respondents to this application, that is that of Hopus Odemma. that means that at the time this matter, Hope Uzodinma's appeal got to the Supreme Court, that particular, his petition was no longer existing by reason of that decision. That is the point. And now, as we have gone to the Supreme Court, what the Supreme Court ought to do was to first of all decide, either rightly or wrongly, that look, we are setting aside that judgment in that cross appeal. It was never done. Now, that is one ground. Then there is the ground of fraud. There is a ground that the Supreme Court did not take into consideration the specific laws of the land, the Constitution. For example, Section 140, that says that in a situation like that, you cannot say that the person that came second, if you decide, or the person that you declare, that you cannot declare the person governor. You cannot do that. All these things are there. And these are valid grounds. Any one of which, if found to be so by the Supreme Court should be able to set aside. We're not talking of correcting clerical mistakes. That is the problem these people are having. And now, when you come to this issue, for example, issue of fraud, you are not statute barred by time. Not at all. That is the position of the law. And it is not going to be determined. This position of the law is not going to be determined by people out there on the street. It is not going to be determined, for example, here, the Supreme Court will decide this specifically and give a sound judgment on it. That is what we believe.
And
I tell you, if we take away, I want to say something, if we take away politics from this case, there is every ground, 100%, that the Supreme Court will act wisely and set aside this judgment. And now, one other thing we want to say is this. Would we want to wait and perpetrate this particular bad judgment, this fraud that was committed?
I think we'll wait for the Supreme Court to give that decision, and that is March 2nd.
On the record,
Mr.
especially the present
I must cut in, and this is to quickly get Mr. Gulag's opinion, because we're also looking at the effect of this on governance. I mean, both your parties, are they looking at the impact this review is having on the people of Imo State, with all the back and forth? Mr. Gulag, if you'd like to respond to this.
Well, like I said, the political class is not helping matters. Their lawyers, too, are not helping matters. Everybody knows that there must be an end to litigation. And the Supreme Court is the final judgment. After the judgment of the Supreme Court on the 14th of January 2020, the matter would have been laid to rest. But people with frivolous applications approach the court. The court cannot drive them without hearing them. That is the beauty of democracy and the beauty of our judiciary. But be that as it may, it has effect on the governance, of course. Attention has been distracted. Hope Uzodinma, the current governor, who is eager and willing to serve his people, to bring in the development they need, is being distracted. They are supposed to allow him concentrate on governance. But here are people who, because of politics, want to bring down everybody. If I can't get it, nobody gets it. If I can't get it, let us destroy it. How can you imagine the PDP leadership going on the street, demonstrating against the judgment of the Supreme Court?
Quickly now, to you, Mr. Alpara, I must quickly get your point of view as we wrap up on this. Mr. Alpara, my question to you is, isn't 2023 another opportunity for your party? What do you think this review is having on the effect of Imolites? In 30 seconds, please.
Now, I want to say something. The people we copied this from are people who know that democracy does not belong to the people, the representatives of the people. It belongs to the people. And the people ought to own it. Now, there was something about a few days ago, and it was cited, a decision of the House of Lords in England, where the judges, the laws, acknowledged that it was proper. There was picketing of the law court, and they knew that it was proper for that to happen because it is in a democracy. The people have to make their feelings felt. I do not know why we always condemn. We want our people to pander to the people at the top. Now, that is, let us give him a little of his own medicine. He is talking about telling the Supreme Court, you did something on January 14th that you didn't take full cognizance of certain things.
We need
Fine.
to go on
Between
break
January
now.
14th
I'm
and
perhaps
now,
going to give
he's
you
now
an opportunity to come back and finish that. Please hold that thought, but we need to go on a break now. Still to come also, one of Nigeria's opposition parties, the YPP, they're seeking good governance. They've stormed the streets of Lagos to demand it when we return. Welcome back to the program. But first, to some of our stories in brief. The President of Senate, Ahmed Lawan, he's asking security officials to beef up security measures at the National Assembly to avert any threat. Mr. Lawan made the comments during a meeting with top security officials at the National Assembly complex in Abuja. Elsewhere, the Forum of All Progressives Congress aspirants, they're calling for a reform in the APC in order to allow it to survive beyond 2023. The call is part of the resolutions reached by the aspirants at the end of their National Executive Council meeting in Abuja. The group, however, clarifies what their call for reforms means, saying it has nothing to do with the removal of anyone from office, as they have confidence in the party's reconciliation committee led by Chief BC Akonde. Elsewhere, the people of the Benue South Senatorial District, comprising the Doma and Igede ethnic groups in Benue State, they put forward a strong case for the rotation of the governorship seat come 2023, which has been occupied by the Atif brothers since 1976, when the state was created. The position was arrived at by stakeholders from the 7 and 2 local councils occupied by the Domas and Igede at the zonal town hall meeting in Otukpo Local Council. All right, we wrap up with our guests on the issue of the Supreme Court hearing the Zamfara and Imo State governorship application till March the 2nd. We've been talking to Mr. Ahmed Gulek, member of the APC, and also Mr. Emeka Opara on this issue. Some people are saying that perhaps there should be a rerun for Imo State. Mr. Gulek, I'd like to hear finally what you think, your thoughts are on this, and also Mr. Opara afterwards. 30 seconds each, please.
You see, there is nothing under the sun that will allow for the judgment of the Supreme Court to be changed. There is no need for that. The judgment of the Supreme Court was clear, explicit, and understandable. No ambiguity. The Supreme Court held, and everybody knows, that ab initio, from day one, Hope Uzodinma won the election. So there's no need for rerun. Allow the man to govern. Let them go and prepare in 2023 or 2024.
All right, Mr. Opara.
They have ample opportunity and time to prepare for that election. You can't saddle the Supreme Court going forth and back.
Let's quickly, thank you, Mr. Golak. Let's quickly hear from Mr. Opara.
Now, I want to say something. And that is, when I hear some of this kind of argument, I ask myself, is it the same election where Hope Uzodinma, under cross-examination, agreed that he tabulated these results by himself in a hotel room, which is a criminal offense on itself? Is it the same election where, out of the so-called 388 units, 214 of it, APC got votes in each of 214 more than the number of accredited voters? Is it the same election where, for example, in serial number 69, where APC got more votes than the number of registered voters? Is this the same election where the number of only 2 parties, by his own results, only 2 parties were there, and the results of the votes of other parties, 68 other parties, were not recorded? Is this the same result which constitutes a criminal offense that they
Mr. Para,
want us
I
to
really
paper
wish
over
we had
and that the
more
Supreme Court
time.
should put down its name?
There's so many issues to be talked about, but we definitely know that the Apex Court will be taking a closer look at some of these issues, and we'll see that justice is not only seen to be done, but then that it is done. We'd like to thank you, Ms. Ahmed Golak, member of the APC, for talking to us, and indeed Senior Special Assistant Legal Matters to the former President, Mr. Emeka Okpara, on this issue.